I'm attorney Phil Giacino, and this is Finding Common Ground here on Altice. You can see this show every Saturday at 10 a.m. on channel 115. Let's get to it. I like to start off each show with a quote from a book that I wrote called Divorce: A Practical Guide. Not my quotes, they're quotes that I came across. It could be Abraham Lincoln, Thomas Jefferson, Tom Clancy. In fact, the author Tom Clancy wrote a nice quote, and it says that the difference between fiction and reality is that fiction has to make sense. Now, I've been doing this 30 years, practicing law, criminal, matrimonial, family court, personal injury. Sometimes reality is stranger than fiction. The first topic I want to talk about tonight has to do with what they call the automatic stays in a divorce case, not family court, but in a divorce case. Years ago, I'm talking maybe 5-10 years ago when I was well into my practice, the law was that if you wanted the other side, so if I'm representing, let's say, the husband, and I wanted to make sure that the wife could not move money around, take money out of a bank account, borrow, take my client off the life insurance or the health insurance, we would have to make what they call a pendente lite motion. Now that still exists, it means pending the litigation, but you don't have to do that for those reasons. So if you want temporary custody, you can make that motion. Temporary child support, and so on. But if you don't want the other side to be able to move money around or play games, you don't have to make that motion because a law was enacted called the automatic stays as per Domestic Relations Law Section 236. That law got rid of the need for making such a motion. Now how does that law help? Let's say I represent a wife and I'm going to file for a divorce. I would serve the husband with a summons and complaint or a summons with notice, and I include a document called the automatic stays. It's a pretty universal form. All the attorneys use the same document, and it says Notice of Automatic Orders, DRL 236. And then it has 5 paragraphs. It's the don'ts, things you cannot do. Once you serve the other side that, if they violate any of those automatic stays, they have committed a breach of the law. They actually violated, in a sense, a court order, because these orders take effect even before a judge gets involved. And that was another reason why I want to talk about this, because too often people don't realize the importance of this law, because a lot of times they don't see an attorney immediately. So they get served, they don't know what they're not allowed to do, and they violate the order. And then they go see an attorney, and the attorney says, wait a minute, you got served papers and you mortgaged your house, or you moved $100,000 out of an account. You're in violation of a court order, and there are consequences. I see it all the time. Let's go over them point by point. The first one says that neither party shall sell, transfer, encumber, conceal, assign, and I'm paraphrasing, any property. It could be real property. It could be personal property. Bank accounts, stocks, mutual funds, cars, boats, anything that is property or has a value. Anything that has a value. So you get served, you can't run to the bank and say, I'm going to take out $50,000 or move $50,000. You can't do that. Now, there are exceptions. One is ordinary living expenses, and the other one is reasonable attorney's fees. So obviously, if you got served papers, you got to go out and hire an attorney. So if you had a bank account with, let's say, $100,000 in it, you couldn't take the $100,000, unless it was, like the Christie Brinkley matter. You're not going to be able to pay that attorney $50 or $100 if that's not reasonable attorney's fees. But you can use what's reasonable. Also, reasonable ordinary expenses. Now, what are ordinary? Let's say you have a bank account that has $50,000, and each week it's customary in that family to take out, let's say, $1,000 to pay a bill. You're allowed to continue to do that, but it has to be ordinary and customary. It can't be from out of left field. So you can't say, oh, I never touched that money, but now I'm going to put my salary in the bank and I'm going to start drawing off this as in for ordinary living expenses. It wouldn't be ordinary because you never use that account for that purpose. So a judge can say, you're playing games. You pocketed your salary or whatever monies you received, and you're taking from this account. That's a violation of the order. Another one is, you can't encumber, assign, withdraw, or dispose of any money in tax-deferred funds, stocks, or other assets held in any individual retirement accounts. So if I have a 401k and I get served these orders, I can't say, you know what, I'm going to put these in my brother's name. You can't do that. Another one has to do with borrowing. You can't borrow. Let's say there's a joint credit card. You can't run out and buy a lot of stuff saying, well, that's also my credit card, but you're affecting the other party. It says, neither party shall incur unreasonable debts, including but not limited to further borrowing against any credit line secured by the family residence, so you can't take out a home equity loan. Now, if it's in both names, you really wouldn't be able to do that unless you perpetrated a fraud. But let's say the house is only in the husband's name. He can't run out and get a home equity loan unless there's consent, and it should be in writing to make sure there is no misunderstanding. Now, there are exceptions. Let's say there's a joint credit card and the husband files for divorce and the wife has no money and she needs to buy food for the family. She's allowed to use that credit card. That would not be a problem, especially if the husband is not giving her any money. Next is insurance. Neither party can cause the other party or the children of the marriage to be removed from health insurance, existing medical, hospital, dental, and so on. So if I have a health plan and I'm covering my 2 kids, let's say, and my wife serves me divorce papers, I cannot then call the insurance company and say, take my wife off that plan or take my kids off that plan. You cannot do it because the automatic stays say you cannot do that. You'd be in violation of an order if you did. And there are consequences. The last one is neither party shall change the beneficiaries of any existing life insurance policies. It could be whole life, term life, universal. And each party shall maintain the existing life insurance policy, automobile insurance, homeowners, renters, whatever you have. So again, use the same example. I get served divorce papers and I say, you know what, I'm not going to pay the homeowner's policy, or I'm not going to pay the renter's insurance, or I'm not going to pay the car insurance. You'd be wrong, and you'd be in violation of the automatic stays. You have to, what I like to do is tell the client, maintain the status quo. Those are the words I like to use because it's trying to bring across something simple. Maintain the status quo. Whatever you've been doing all along, unless there's a valid reason why you can't. So for instance, let's say a husband gets served divorce papers and the next day he legitimately loses his job. Not that he quit out of spite. He legitimately lost his job. If he loses his health insurance through no fault of his own, he's not technically in violation of the automatic stay because he didn't willfully violate it. He could say, I got fired. I had no insurance. Now he has to go out and try to get a policy or do the best that he can. But that would be an example of that wouldn't be a violation of the automatic stays. But maintain the status quo. Don't try to be cute. Don't say, well, you know, I was paying this, this, and this, and she served me with divorce papers, so now I don't want to pay that. You have to. Now, when you go to court, a judge can change that and say, okay, you know what? The wife has to contribute more now because she filed for divorce. She's got a job. She can't be hoarding that money. That money now has to come into the family if it's necessary. So when I say maintain the status quo, that's certainly initially, it might continue, but at a preliminary conference or because of a motion made by one of the parties, that could change. Now, earlier I used the term pendente lite motion. That means pending the litigation. You don't have to make that motion to protect yourself with respect to the list I just read to you. But if you want other forms of relief, like I said, custody. So let's say a woman gets served divorce papers and the husband says, I'm going to take the kids and move out. First of all, he shouldn't be doing that. Neither one really should take the kids and leave. But she can get an attorney and file a pendente lite motion saying, pending the litigation, while the divorce is pending, I want custody. It's going to be temporary. It's not going to be permanent at that point. But it could give her a level of protection so that a judge says, no, you have custody. He can't take the kids and move out. Or the husband has custody and the wife can't take the kids and move out. Or neither party can take the kids and move out. In other words, if they're in a home and the husband wants to move out, he can move out. Wife wants to move out, she can move out, as long as the kids are taken care of. But you just can't unilaterally say, I'm giving myself custody. That would be for a motion, or at a preliminary conference where the court talks to the attorneys and says, you know what, in the meantime, leave the kids where they are. Or if there's an order of protection, let's say, against dad, mom might be able to take the kids and move out, and dad can't follow because of the order of protection. Or he can't be around the kids even, that happens. So very, very important. What I'm trying to say is get yourself a good attorney, come to somebody that has experience and knowledge that can advise you right away. You don't want to make decisions that are going to come back to bite you in the butt, because it happens all the time. Even with these automatic stays, a perfect example. A person is served these automatic stays before they even have a chance generally to hire an attorney. So if they don't go through the paperwork, and the automatic stay is part of it, but it's not the first or second page. If they don't realize, they might just get the paperwork and say, next week I'll go see an attorney. And within that week, they start moving money around or taking people off insurance policies, they're going to get themselves in trouble. There's going to be consequences, because then if the attorney has to make a motion, let's say, or to bring the case in, and there are attorney's fees, the person who violated the automatic stays might be penalized by having to pay attorney's fees. So very, very important to find out what's going on immediately. You get served these papers, you should be on the phone the next day calling an attorney. And these are the kinds of cases that I handle: divorce and family court, criminal, personal injury. But my specialty is family court, divorce law, and criminal. And there's a lot of overlap, you can just imagine. They have orders of protection that affect people in criminal court, in family court, in Supreme Court. I had a case recently where we had set up a 5-way conference to meet with the attorney for the child, the parties, and the attorneys. And there was an order of protection against my client, stay away. So he couldn't even be in the same room as the wife. We got permission from the court. We changed the order of protection to allow for that meeting. Otherwise, I couldn't in good conscience say, all right, come on in, because I'm part of that violation of the order by allowing my client to, let's say, sit across from the wife, who could then pick up the phone and say, he's in front of me, he violated the order. Now, that would be dirty pool, but that could happen. Or if something gets said in the meeting that's taken the wrong way, she could pick up the phone and say he violated the order of protection. So it is important that you get some direction right away so you know how to conduct yourself. And as I was saying, there's overlap. If there's more than one case, let's say you have a divorce, you're in Supreme Court. You have a family court case, you're in family court. You have a criminal case, you're in criminal court. However, what if you have a divorce pending and then they get an order of protection against you in family court, or get you arrested in criminal court, or for the violation of the family court order? Again, it can get complicated. What happens? The case in Suffolk County can go to the integrated matrimonial part, or the integrated part, which is before Judge Krecker. He can handle a number of different types of cases. It's an integrated part. It's like one-stop shopping. So you don't have to run to Supreme, then go to family, then maybe go to district court. In that courtroom, an assistant county attorney is there that can handle certain types of cases, like a neglect, let's say. There's an assistant district attorney who can handle the criminal cases, and then the attorneys come in on the divorce. Sometimes the case is called first without the DA, and then you say, okay, now we're going to call the criminal case. So maybe the other attorney can leave, and if it's my client that's charged criminally, we handle that case. And sometimes it's good, sometimes not so good, only because sometimes you can get bogged down. There could be a lot of cases on. You may have to wait for the DA who might be handling another matter, all right? Or there are conferences. So it can be a good thing. Just be aware when you're in that part, all of the cases that are involved with respect to that matter are handled by that particular judge, as opposed to the individual family court, district court, and criminal court. What I want to do now is what they call some frequently asked questions. I compile them through the years, and these are questions that I feel people need answers to. These are questions that I get asked a lot in my practice. It could be somebody bumps into me in a hallway. I get that a lot too. They come up to me and they say, oh, by the way, I got this kind of case. What does that mean? Or what should I do? And I give them some advice. I give them my card. And sometimes they come in to see me. Sometimes all they needed was that information and they're on their way. One of the frequently asked questions I get is, what is the difference between probation and interim probation? Now, they're both forms of probation, but what is the difference? Generally speaking, if you're charged with a crime, one of the ways it can be resolved, obviously, is jail. One of the ways is a fine. One of the ways is probation. With a violation, there's no probation. There's a conditional discharge or a monetary fine, and that's it. With a misdemeanor, it could be 1 year probation, could be 3 years probation, could be 5 years probation if it's a felony. Could be 10 years if it's a sex crime. But what is interim probation? I'll give you an example. Let's say I have a client, doesn't have a bad record, and the DA says, I want 3 years probation. They committed an assault. It might not have been the worst crime committed. There might have been even a rationale or an excuse. Let's say somebody found out that somebody's wife was dating some guy and he went to him and all of a sudden there was a fight. That could be understood. I'm not justifying it, but that could be understood as compared to somebody just randomly going up and punching somebody in the face. So you maybe don't send that guy to jail, but you put him on probation. But as the defense attorney, I'm going to push a little bit. And I'm going to say, can we do interim probation? And this is what it means. The client would plead guilty, let's say, to the more serious charge. Could be the felony, could be the misdemeanor. Does 1 year of interim probation, still probation, alcohol, narcotic conditions, has to see the probation officer, has to live by certain rules. At the end of that year, if that probationer did everything he was supposed to do, or she was supposed to do, they will be given a better deal. So it'll be worked out ahead of time. They'll say, plead guilty to the misdemeanor. At the end of the 1 year interim probation, you come back and you plead guilty to disorderly conduct or to harassment, which is a great deal because then you're not going to have a criminal record. For a little while you did, but ultimately the final disposition will be, in the example I gave, a violation of law, which is a fine and not jail, not a criminal record. Very important. You avoid the criminal record. Now, sometimes that's not offered or you can't get. Depends on the crime, depends on the circumstances. But it's something. And now you know the difference between probation and interim probation. Another frequently asked question I get is in divorce cases. Now, by now, most people understand that you don't get a jury, but I get that question, say, you know what, can I get a jury in my custody case, let's say, either in family court or in Supreme Court, divorce court? Can I get a jury? The answer is no. Years ago, for grounds, you had a right to a jury, but now the law had changed some years ago. It's irretrievable breakdown. You don't need to prove adultery, cruel and inhuman treatment. So you don't see trials anymore for grounds. But you don't get a jury trial for any other issue in family court or in Supreme Court for divorce cases. Car accident cases, of course, medical mal, criminal cases, misdemeanors or felonies, not violations. You get a jury. Youthful offender, you wouldn't get a jury if it's a misdemeanor, but that's one of the exceptions. So one of the things when I tell the client, like in a criminal case, let's say, let's just say for some reason I don't think the judge would do us any favors if I went with a bench trial. I might say, you know what, Judge, give me a jury trial. So I know that the guilt or not guilty verdict will come from a jury of 6 if it's a misdemeanor, 12 if it's a felony, not the judge. Because the DA only has to convince the judge of my client's guilt, and my client is found guilty. The DA has to convince 6 people in a misdemeanor trial or 12 people in a felony that my client is guilty beyond a reasonable doubt. In a divorce case or family court, there is no jury. So the judge you go before, pretty much from day one, unless the judge would have retired, die, or get moved to a different court, which happened recently. Judges are moved around. A referee won a judgeship, they moved to a different court, so we got somebody else. But for the most part, when you get assigned a judge or a referee or even a support magistrate, you generally have that individual straight through. And even if you come back, if that judge is still on the bench in the same capacity, you will generally get that judge. So if there's a modification down the road or a violation, they will generally send you to that same judge who knows your case. And you may even get the same, you used to call law guardians, attorney for the child. But since you don't get a jury, that judge, and you're going to get, if you're a good attorney, you're going to get a sense of what that judge believes about your case, the comments that are made, the rulings that are made. So I'll give you an example. Let's say I go in and the judge is like, Mr. Giacino, and it might be a conference not in front of the client. What is wrong with your client? Why is he doing that? Or I'm going to have to punish him. I'm going to have to order him not to do this. Or he just tested positive for drugs, so I want him in this program. I'm going to try to, as best I can, settle these cases. I try to settle all cases, but sometimes you can't, and sometimes you can. In a case where I know the judge is not smitten with my client, I'm going to tell my client, look, you can roll the dice and go to trial, but I can't get a jury for you. So if you don't settle the case and we go for a trial, that judge will make the decision. And if I'm hearing negative things now, it might not get better after trial, it might get worse. And when there's no jury, you're more likely to get a sense from the judge as to what he or she is going to do. They're more likely to, in a conference, say, okay, you know what? I heard that the kids want to live with mom. Mom seems to be a good mom. Dad has some issues. Where are we going with this? We have a trial. Unless I learn something new, mom is probably going to win custody. And we have these kinds of conferences, generally in the back or off the record, or with the clients not in the courtroom. We do that frequently. So as a knowledgeable and experienced attorney, I get a sense of what is going to happen, my client's fate. I know it. Right? I don't have to be beaten over the head to realize when my client is in great shape and when he's not. And I use that information to advise my client. I wouldn't be doing my job otherwise. It's like a doctor that might have to do surgery and he knows that the person might not survive surgery or that surgery might not be best for that particular patient. It's the doctor's job to say, you know what, this is not a good way to go. Same thing in the law. I'll tell my client, this is a good decision. This is not a good decision. I think you need to go to drug counseling, or don't involve your significant other when you're seeing your child because the judge is saying don't do that, or I don't think it'll be good. I can factor all these things in based on my knowledge and based on my experience. I've been doing this almost 30 years now. Actually, 30. I started in 1989, so here we are in 2020, going into my 31st year. So I'm in a position to be able to tell you what I think you should do. And the last show I did, I talked about when you hire an attorney, hire one you're going to listen to. If you're going to argue with me, and I get that, they'll be like, wait a minute, I disagree. Okay, you disagree. You're allowed to do that, but who is the lawyer? Who went to law school? Who's been practicing 30 years? Me, not you. Now, your brother might have had a divorce 5 years ago in Jersey. That doesn't make you an expert. I'm the expert. Right? The judge knows the law. The other attorney knows the law. You may have knowledge. You might be a very smart person, but even if you knew all the laws that existed, the practical side of it is, how is it applied? How does the DA treat in a criminal case? How does they conduct themselves? How does a judge look at things? I've seen some people come in and I know the law, it's black and white, and then they get their butts kicked because they go in there and they think that citing a statute is going to win the case, and it's not. Sometimes it does carry the day, but you have to know the law, you have to know the facts, you have to apply the facts to the law. That's what they teach us in law school. Very, very important. Sometimes you got to know what not to say. That's also important. Because sometimes I say to my client will say, I want to tell the judge this, I want to, don't volunteer any information. That might not show you in a good light. Sometimes things backfire, where a person comes forward with information and it might not be what they want to tell the other side. And I'm not saying you lie to the other side or you hold back information when it involves, let's say, discovery. But always talk to the attorney that you trust, that you're paying. He or she is the attorney that you should be listening to. Because if you're not going to listen to them, fire them. Get another attorney. If you think you know it all, represent yourself. It's not a pretty sight. All right? I hire people all the time to getting windows installed. I'm not doing it myself. My car breaks down. I'm going to a mechanic. I filled my air up today. I could do that. But I will go to a mechanic. Right? If I'm sick, I go to a doctor. I don't try to do these things on my own. You know, there's certain like websites, people say, oh, I can diagnose my own disease. Nah, maybe not a good idea. We could do research and find out different things, but still see the expert. The attorney is the expert. Another frequently asked questions, and this has to do with a divorce case, unique to a divorce case. Am I entitled to my spouse's pension? Now, for the most part, most people know that they are, but they're not sure what they're entitled to. I'll give you an example. Let's say, and this had a similar case. A client came to me and said, my husband's a cop, and he's about to retire, and he's going to have a big fat pension. I said, how long has he been a cop? 20 years. How long have you been married to him? 2. You're not getting much. Might not even be worth it to pursue, but you're certainly not getting much because you would only get the marital portion. Now, what is the marital portion? They use the Majaskis formula. There's a numerator, denominator. So if that cop, I'll give you an example. Let's say the cop started his career as a police officer in 1980, got married in 1990, and got divorced in 2000, going through a divorce. What is the marital portion? 90 to 2000 when the divorce was filed. Now, if the divorce is filed, let's say in 2020, and the case drags on for 4 years, it's still 2020. Like a joint house that goes up in value, that's fair game. But the pension, IRA, 401k, annuity, the cutoff is when the divorce is filed, unless the parties agree otherwise. The start point is when the person got the job and started contributing, or when they got married, whichever comes later. So the lady, I had to explain to her, and she said, well, my girlfriends, they're getting big fat pensions from their husband. Yeah, but they were married for most of that 20-year period, or a good portion of it. 15 years, yeah, you're going to get 15%, you know, maybe 75% of his pension. 2 years, not much. Right? Also, the person, like I gave the example, 1980, became a cop in 90. From 80 to 90 would be his separate property. The wife would not be able to touch that money, or those monies that would be paid, let's say, to him. So you hire, no attorney in his right mind does a quadro. Quadro is a qualified domestic relations order. A DRO is prepared, domestic relations order, a judge signs it, it becomes a quadro. You pay usually $500 to $600, you hire a company. No attorney in his right mind would do it himself. We hire the expert. Perfect example of getting somebody that has the expertise. Because if we make a mistake and we hurt our client unintentionally, the client could sue us. We'll say, wait a minute, you didn't calculate the pension right. And just like I wouldn't do my own taxes. I could to some extent, but I have an accountant. Or if I need a forensic analysis of a business, let's say, I'm not going to do it myself. I'm going to hire somebody. If you need to know what a house is worth, it might be pretty simple. Go to Zillow. You still get the expert. So with regard to the pension, the 80 to 90 would be the police officer's separate property, and in that middle, you would get half of that. When the person retires, if it's a pension, if it's some other kind of account, it could be before that. Let's say it's an IRA. You could do a rollover. You might need a quadro. A rollover would be where you don't need a quadro. You take, let's say the guy has $100,000. the wife goes and gets, hires, let's say, or opens an account in Charles Schwab or TD Waterhouse, whatever, and rolls the $50,000 that they'd be entitled to into that new account. So this way there are no tax consequences. You don't get hit with income, because if you just took, let's say, $50,000, stuck it in your account, and then say, well, what am I going to do with this money? You're going to get hit with a penalty if it's a protected retirement account, not a brokerage account, not a savings account or anything like that. An account that's designated as a retirement account. And I said them before, IRA, 401k, annuity, pension. Some of those you can touch earlier, but there will be penalties. Once they roll it off, it's almost like you work for the company and you earned that portion that you have. So that's your money, right? If you borrow against it and there's a penalty, you're going to suffer the consequences, not the spouse, because he has his, you have yours, right? So again, here's an example of get some advice before you start making decisions, because sometimes people withdraw money, get hit with a tax consequence, or they do things that could affect their ability down the road. Also, you'd want to make sure that there are survivor benefits regarding the pension. Because if you don't, let's say the person made a decision at some point and said, I don't want survivor benefits. If I die, the pension dies with me. Why do they do that? Because they'll get more money. But the spouse will get screwed. So the wife, or the one getting that portion of the pension from the spouse, would want to make sure there are survivor benefits so that if the person dies, they get their portion. Not his portion, but their portion. And also make sure that if there is no survivor benefits, you deal with it by getting insurance. So let's say, in a simple example, you have a 401k and it has a couple of $100,000, but there's no survivor benefits. So the wife would get 100, but if he dies, he might not get it. And 401k probably would, but let's say a pension or something that would die with the person. You might say, okay, he's going to have to get a $200,000 life insurance policy, because if he dies, she doesn't get anything. She doesn't get what she bargained for, which was half the pension. The life insurance term, let's say, could compensate her if he dies. We also see life insurance when it comes to spousal maintenance and child support. Why? Because if the husband has an obligation to pay child support and maintenance, what happens if he dies? No more payments. So you'd have a life insurance policy. And you don't need $1 million if it's a smaller, let's say, small payments. You calculate it. What I do is I say, okay, in a simple example, the kid's 15, child support to 21, 6 years. How much is it going to be? $1,000 a week. Do the math and say, okay, it would come out to, we're just pulling a number out, $50,000. Oh, and there's maintenance, and that'll come out to another 50. So the husband should go get $100,000 life insurance policy to cover his obligation for child support and maintenance. Now, that could be decreasing as you go along. So in, let's say, 3 years, the child's closer to being emancipated, and let's say maintenance is over. The husband shouldn't still have to have a $100,000 life insurance policy. Maybe at that point it's down to 30, just to cover the smaller obligation. So that's one way to look at it too. The next frequently asked question, and this comes up even in the middle of a divorce, is discovery or disclosure. I remember my cousin Vinny, it's disclosure, you D-head, he has to tell you. That is very big in divorce case, and criminal cases, of course, too. But in a divorce case, what does the person make? How do I calculate maintenance or child support or anything if I don't know what the husband makes? And I don't want to just rely on an 2018 W-2, because he might have made a lot more money in 19. And maybe he's making more money in 20. It's too early to tell just yet, unless he has like an employment contract. But if it's later in the year, you extrapolate, you figure out, oh, it's November, he's already made 100 grand, so he's probably going to make 110 or 120. Last year he made 80. I'm not basing child support on 80 if I know the guy's making 120. So disclosure, discovery is very, very important. Now, I have a lot of clients that say, well, I don't want to tell the wife I have this or I have that. Well, the other side might not want to tell me or my client what they have. We always say, and I heard a judge early in my career say, there are no secrets in a divorce when it comes to finances. You have to be forthcoming, because if you get caught in a lie, you're going to lose all credibility, or even an omission, because you're going to have to fill out a financial net worth statement. It's usually like 18 or 19 pages. In family court, it's only either 2, 3, or 4 pages. But in a divorce, all your expenses, all your income, all your assets, all your liabilities, you have to put that down. Both parties. And the document's basically identical. The husband will put down what he's paying, the wife will put down what she's paying, or what she anticipates having to pay once she's no longer living with the husband. So we can say to the court, look, she's going to have $2,000 of expenses. She only makes $1,000, let's say it's a month. She only makes $1,000 a month, $2,000. She needs child support, she needs spousal maintenance. And if I don't lay it out, the judge might say, well, how do I know what she needs? Well, it's right here. And then you can back it up. If you have a lease, let's say it's rent. You have a lease. Here's the lease. I'm paying $2,000. Well, here's my credit card statements. Well, here's my insurance. Whatever you have to prove what you're paying so you can help your client get what they're entitled to. So in addition to the financial net worth statement, it has to be filed with the court. So it better be accurate. And the attorney should be careful. So if I have a client that says, I have 2 boats, and he doesn't put them down, the attorney should say, where are the boats? Put them down. I don't want it. You have to. The attorney doesn't want us to suborn perjury. And you're certifying that that document is true and accurate to your knowledge. Now, if the client's telling you a big fat lie and you don't know about it, there's nothing you can do about it. But if you know there's a boat, you have to say to the client, you got to put that down. What other forms of discovery is there? Bank records. So in addition to a financial net worth statement, which can be like a tax return where you're putting down things and it may or may not be accurate, bank records. You may say, all right, we need 3 years bank records. That'll tell me what's coming in, what's coming out. I won a case not that long ago where I used some bank records to show what was coming in, that the person wasn't pulling monies out to pay bills, so there had to be a cash source. And the judge accepted it with the evidence we had and gave my client a very good spousal maintenance order, where without that information, the court might not have said, oh, I think he's hiding cash. How would they know? But that's why the attorney has to build the case. I'm not an accountant or anything like that, but I was a finance major in college, but I know how to build a financial case. You could start with the financial net worth statement, pin them down, or send a discovery demand. Sometimes I don't like to do that if it doesn't apply. Let's say you have a simple family with one house, each one has a W-2. Why send a ridiculously long discovery demand to the other attorney, unless you're padding your bill? You don't need to. Now, if the guy has a business and has 5 pieces of property and he's making cash, then you do what you have to do. But I like to do it surgically. I say, okay, please send me this, send me that. I make a list. So it saves me time. When I get it back, I don't have to go through something that's 20 pages. I say, okay, I want his 2019 and 2020 W-2. 1. I want his pay stubs for last year. And you got to also know what you're looking for. Because if you're looking for something a year past, you don't need 10 years of bank records. That's only going to increase the cost of the case, because the other side has to put that together, and then you're going to read it when you get it. You might not need to. Now, one time, you're usually not allowed to go back that far. One time I was able to go back 9 years because it was relevant to the case. There were some issues that went back that far. Most of the time there is not. And I was even surprised the judge said yes. She said, okay, I'll let you do that. I made my case. I was almost expecting her to say, we're not going back 9 years. Usually you see 3 years, 4, 5. Again, know your case as the attorney and as the litigant. Say to your attorney, hey, I don't need her 5 years bank records because I know she's a W-2 or she didn't work. Why would I want all these bank records? And if they're jointly held, I get them from my client. I don't need them from the other side if they're joint accounts. Depositions. What's a deposition? A deposition, and I had one not that long ago in a case, where I'm allowed to ask questions of the other side. They are allowed to ask questions of me. It's not a trial. There's similarities where I'm questioning a litigant. Everything that's being said is being taken down. So let's say I have the husband, I'm questioning the wife. The wife's attorney questions my client. We're sitting there all together. There's usually no cross-examination. You ask the questions, Everything that's said is taken down, and you can correct it later. Unlike a trial, you can correct it later. You can say, I said yes, I meant no. I misunderstood the question or whatever. Or I said it happened in June of 2018. After I walked out of there, I looked at my calendar and it was July of 18. You can correct it. You correct the record. If you don't correct it, it's deemed admitted. So at trial, if you tried to do this, say, no, well, you didn't correct it. So the court could think you're trying to pull a fast one, or you didn't read the transcript carefully. And then documents get followed up. You could say, did you get your W-2 for 2020 yet? No, yeah, it's at home. It's sitting on my desk. Okay, Exhibit 1, you're going to give your attorney that to give to me. So I make a list. I want this. I want things that he doesn't happen to have on him, or she. I can make a list, and they have to give me those things. So discovery, disclosure is very, very important. It gives the attorneys the information they need to settle the case or to litigate the case. Because you can't settle it if you don't have all the pieces of the puzzle. And you can't litigate it, it's the same thing, if you don't have all the pieces of the puzzle. You need that. You wouldn't be doing your job if you didn't seek information, discovery, disclosure, right? Now, in a criminal case, they're also very, very important, but the focus might be a little different. It might not be, let's say, bank records. It could be witness statements. It could be a video. Now, some of those things are called Brady material. I've done shows galore on Brady violations in criminal cases now. And you read Newsday, you're going to see DAs notoriously fail. Sometimes it's intentional, sometimes it's not. They fail to give information that they are supposed to turn over. Now, what is Brady material? Nothing to do with Tom Brady. It has to do with information the DA has, the police, and they give it to the DA, that can exculpate the defendant. In other words, it could be an alibi. It could be information that shows the guy didn't do it, or can be used for impeachment purposes of another witness. Or could be handled in, let's say, the sentencing phase. It could be a mitigating factor. So remember the example I gave you earlier where he said, let's say a guy assaults another guy and it's because the guy was fooling around with his girlfriend or his wife. Now, that could be a mitigating factor. It's still assault. It could be a mitigating factor. Now, let's say the DA has information that would show that that guy was fooling around with the defendant's wife or girlfriend. They would have to turn that over, because at the sentencing phase, if I had that information, I could say, Judge, my guy is an honest, law-abiding citizen. He came home and he caught this guy, and this is what happened. And as proof, I have this. So you have to, the DA has to turn it over. I'm a former prosecutor, assistant district attorney in Suffolk County. We had to turn over that documentation, whether we liked it or not. You turn it over. Because if you violate Brady, the case can be thrown out, or there could be some punishment. The defense, the prosecutor might not be able to call a witness, or the defense attorney might get some relief that he might normally get. I'll give you a perfect example of Brady, and I've used this example before. Let's say your client is charged with a shooting. And your client is white, and he's 6'6". And there's a witness statement that the DA has that said a short Asian man was seen running from the scene right after people heard pop, pop, pop. In other words, shots being fired. Now, does that mean that smaller Asian guy did it? Absolutely not. Could he have? It's possible. The DA can't say, well, that's probably not the theory of their case, so I'm not going to turn it over. You have to turn it over. If you don't, there could be consequences. Now, what does the defense attorney do with that? Analyze it, look at it, say, how close in time? Was it pop, 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 and the smaller Asian guy ran because he heard the shots? Most of us would, if we didn't have a weapon and you hear shots, you're getting the heck out of there. Or could it be that he was the one that fired the shots? So the defense attorney has to look at that. And maybe 3 witnesses say the Asian guy, and then maybe one of the witnesses said, and he dropped something. Or he had a gun or something like that. The defense attorney has a right to know. Because even if it doesn't totally exculpate his client, it could lead to, let's say, something on cross-examination. So let's say, perfect example, let's say the DA puts on someone that says that guy shot the victim. But let's say that same guy gave a statement months earlier or a year earlier that said, I saw a small Asian guy running from the scene. I can cross-examine the witness and say, my guy's white, 6'6", you see him? Now, there was a smaller Asian man running from the scene, and you said that, yes. How soon after? Oh, immediately. Could you see anything in his hand? No, I couldn't. So I'm trying to create reasonable doubt, saying maybe he had a gun in his hand. I don't have to prove conclusively that he did. Maybe he did. I'm creating doubt. I'm breaking down the district attorney's case. He has to have a very linear case. A, B, C, D, E. This is what happened. The white guy showed up. He had a gun in his hand. He pulled the trigger. He shot the other guy. The other guy fell dead. We have a murder case. Or he shot him in the arm, and we have a serious assault case, whatever the case might be. But as a defense attorney, I don't have to prove or necessarily disprove anything, but I can punch holes in the prosecution's case. And one of the ways I do that is with documentation given to me by the prosecutor. How else would I get it? Now, in high-profile cases like the O.J. case, or I forget the actor's name who played Beretta, he was charged with murder, or even Shatner, I think, was charged where his wife had died under suspicious circumstances, so there was an inquiry. Right? Those kinds of cases, if you're an attorney, things can fall into your lap because people want to become famous. I remember the O.J. trial where people were coming out of the woodworks. Cato Kalin, remember him? He was a witness, and he came out. I heard a pounding on my wall, and he was O.J.'s guest. These are things that are necessary for the defense attorney to know about, but not often is he going to be told, because the prosecutor could hold back on that information. I can't walk into the DA's office and go through his file. Right? He has to get me that documentation. And laws have changed recently, making it even easier. They have to do it sooner. Rules have taken effect here in New York that make it easier for the defense attorney and harder for the prosecutor. But the prosecutor is held to a higher standard. It is their job to make sure that the defense attorney gets all the documentation they are entitled to. And if they have doubt, maybe don't bring the case. I know there's pressure sometimes, especially the big cases, to get the bad guy. Especially, let's say a child is killed. You want to get somebody. You want to punish the guy who did it. But you don't want to punish the guy who didn't do it, because that's unfair to the guy that didn't do it, and the guy that did it is still out there. That's the problem with these cases where the wrong guy is convicted. Not only did you destroy his life and the lives of his family, you are letting the guy, I'm saying if you did something wrong to allow that to happen, you are letting the guy that did it out there to commit more crimes. And that's the shame of it. It happens. In fact, next week I'm going to talk about a case very interesting that involved Larry David, who's the co-creator of Seinfeld. And I did a show on that a while back. Might have been internet. I don't know if it was TV. And just in a nutshell, because of Larry David's show at Dodger Stadium, a criminal defendant was provided an alibi that he would have not otherwise had. He was going to go to jail for a long, long time for killing a young woman. But because of what I'm going to talk about next week, it provided an alibi. You could see it. And then other technologies were used as well to lengthen the alibi. Because they saw him at a certain time. There was still the opportunity had he ran out of there, hopped in his car, but then they used other technologies. So it put him there, and then with the other technologies, it showed that he could not have committed that murder. Now, that doesn't happen every day, where you have a celebrity filming where you happen to be located. So most of the time, you don't have that. And sadly, many times, you don't find out some of these things until years later. And people like Marty Tankleff served 17 and a half years in jail. He's been on my show before. And he was later exonerated. Or other people where people come out 10, 15 years later, or through better science, DNA, things like that. Things come out that maybe weren't known in 1980 when the guy first went into jail. Or maybe a detective did the wrong thing, was corrupt or incompetent. It happens. So that's why it's very important in a criminal case, again, to get yourself a good criminal defense attorney, be honest with the attorney, will tell him or her everything they need to know. Because the worst thing I always say to a client, I don't want a bad surprise. If you did something, tell me. Because then you weaken the case. I'll give you an example. Let's say a guy says, I wasn't even there the night of the shooting. And then I find out he was. I was there, I'm sorry, but I didn't do the shooting. Do you see how you lost credibility? Falsus in uno, falsus in omnibus. You lie about one thing, you lie about many things. So then I tell the DA, who I said my guy wasn't there, now I have to backtrack. Now the DA understands I'm not the one lying, but it hurts my credibility when I say, well, all right, he was there, but he didn't do the shooting. Well, you said he wasn't there. Well, he told me he wasn't there. You've lost major, major credibility, street cred. Because anything you say after that, the DA is going to say, well, I don't know if I believe him. And you don't want that. That's one of the worst things that could happen. Right. In the last 2 minutes we have, I wrote a book, if my producer can put up the book. I wrote a book called Divorce, A Practical Guide. It's a great source of information. I call it from soup to nuts. It starts out, what do you do before you file for divorce, or maybe before you even serve papers, before you hire an attorney, once you hire an attorney, what do you do after you've hired an attorney? We talk about orders of protection. We talk about discovery. I have a sample financial net worth statement that you could look at in the book. We talk about marital property, separate property, equitable distribution in New York and certain states, community property, which you see more in the western states. We even talked about Obamacare and marriage. So it's a good source of information. It's a good read before you do anything. And it covers some criminal, mostly matrimonial and family court. It's a good source of information. Because you always want to be a better consumer. Like if I'm going to go buy a TV, I don't just walk in and say, which TV should I buy? I do my homework. I might Google Samsung or some of the Philips or something like that. Now that doesn't make me an expert, but at least when I go in there, I could look and say, okay, I want to get a 65-inch. Which ones are the best? And they might say Philips is the best or whatever. So when I go in and the salesman tries to sell me on a piece of garbage, I know he's full of baloney. I might say, wait a minute, isn't Philips better? Yeah, but this or that. And you want to compare apples to apples. You don't want to be cheap and get a TV and then it's not what you want. So very important. Read the book if you have the opportunity. You can go to my website, JacintoLaw.com. There's also other information there. And when you're considering a particular case, good source of information. I want to thank you for watching the show. Every single Saturday at 10 a.m., channel 115, you can watch the show. I hope you learned something, and I think you will if you listen. I try to make it for the average person, the litigant, not the judge, not the attorney, although you never know, they may learn something too. But I do it for the average person that is going through a tough time. No question. This is not an easy time when you go through a divorce or family court or a criminal case. It affects you, it affects your family. You want to be in good hands. You have a great day. Take care.